see that. Okay. All right. You may proceed, counsel.
Thank you. May it please the court, my name is Nick Reed, certified legal intern under the direct supervision of Howard Blumberg, assistant public defender, along with Michael Veer representing the appellant, Mr. Fidel Fernandez. This time I reserve 1 minute for rebuttal. The search of Mr. Fernandez's property was invalid because the consent he gave officers was tainted by 2 prior Fourth Amendment illegalities. The first Fourth Amendment illegality occurred when officers trespassed on Mr. Fernandez's property over the threshold of an open gate as he was trying to leave his property.
The gate's open and he walks in and that's trespass?
That's correct, Your Honor, in this case. I understand that there is a lot of case law that says that when gates are open, there's no expectation of privacy. However, in this case...
Well, your analogy is it's like the door to your house. If you leave the door to your house open or you're coming out of it, you don't expect somebody to go charging in or to just help themselves to walk in.
That's correct, Your Honor. I understand there's some distinction between the front door of the house and the gate, but in the sense that it establishes the protected area of curtilage.
Well, because you have to look at all of the surrounding circumstances. You have a property that's completely enclosed by fencing, shrubbery, blocking the fencing. It's gated, and under the circumstances, as I understand it in this case, the gate only opened because Mr. Fernandez was attempting to leave his house and was going to drive out the gate. It wasn't like it was left open, all day and all night. It was open only for that finite period of time so he could maneuver his car out the gate, correct?
That's exactly right.
You have to look at all the surrounding circumstances to determine whether or not there was this reasonable expectation of privacy within the curtilage of that home.
That's exactly right. And for that reason, Mr. Fernandez's home was, at all times, even when he was leaving while the gate was open, he had an expectation of privacy. It was violated when the officers crossed past the threshold of the gate.
All right, go ahead.
Yeah, were you able to read Pereira, which I think was probably served on you yesterday as a supplemental authority?
I believe so. I did read it. I don't remember exactly which one it was.
Okay. It is a case that seems a little bit similar in the sense that it's the injury. Unfortunately, they didn't get to the dog sniffing aspect of the case. They only addressed the seizure aspect, but they had an anonymous tip. They go to the premises, and it looks like a curtilage issue as well. If you haven't seen that one, it also seems similar to me to Triana, if you want to address that one.
Yes, sir. Well, I'll start with Triana. In Triana, the distinction is clear that the officers were off of the property. They asked permission to come onto the property. Once permission was given, the officers came on and there was no issue. The distinction would be in a similar alleged knock and talk in Quintana, which is out of the Middle District, where the officers entered onto the property in hopes of doing a knock and talk, but the entry had already been the violation at that point.
Actually, isn't Pereira distinguished in that it specifically says in the holding in the case is that admittedly there was no evidence that the front yard or porch was enclosed by a fence or any other structure and was in fact open to the public.
Yeah, that's
very different from the facts of this case.
That's correct. And the other cases were similar, that the gates weren't used as gates, essentially. There was no prohibition for the public to enter.
All right, let me ask you a question.
Yes, sir.
Did you see my cousin Vinny?
I did.
Remember at the tail end when he has his girlfriend on the stand and they're talking about the tire tracks and he says, "Does this hold water?" Something like that.
After she'd
figures it out, cracks the case wide open. That's something. This is my defense, hold water. Something like that. Remember that part?
I did.
Let me tell you what I perceive to be the leak in your case.
Okay.
And maybe you can help me with it. Consensual and credibility findings. Did that occur in this case? Trial court making credibility findings determines consensual.
The court did determine credibility, yes.
And determined it was consensual. You can only do that based on the credibility at that point.
That's correct.
I see that as some water linking here. Can you plug that up with some fingers in the hole in the dike here?
Absolutely, Your Honor.
Go ahead.
In De Lorenzo, a 2009 case, the court held that when the consent is given after Fourth Amendment illegality, as here, it's presumed involuntary and it becomes invalid when there's no break in the chain of events. It is a fruit of the poisonous tree argument at that point. And here, there was no time passage, especially given the second Fourth Amendment violation, a seizure, between the illegality and when consent was given.
So as a matter of law, you're saying that this consent is always not a voluntary consent.
Correct.
Well, that's not, no, I don't think you're saying that. You're saying that unless there's a sufficient break to alleviate the chain.
That part is correct. Once there's a break in the chain of events, then consent may become voluntary.
No, but I believe you're saying there was no break, and therefore, as a matter of law, it is involuntary.
In this case, there was no break.
Any way you turn the prism, any way you turn it, it doesn't make a difference. Ab initio, from the beginning, cannot have a willing, knowing, voluntary, traditional, yes, you can come in, I have nothing to hide, search. Well, in this case, I only have small plants.
That's correct.
Okay. All right.
So as to the second Fourth Amendment violation, the seizure, when Mr. Fernandez was attempting to leave his property, the four officers converged through the gate soon with...
Well, they did block his egress, is that correct?
I'm sorry?
He couldn't leave if he wanted to because they pulled, I believe it was Officer Falcone or Detective Falcone, drives up right in front blocking him leaving, is that right?
It was Detective Murillo, but yes.
Oh, that name's wrong. Well,
yeah.
Falcone's somewhere in there, okay?
That's correct.
I get him confused. All right, I get my name confused. So, blocking his leaving his property, then walks up to him and says, I got to talk to you, or I want to talk to you, or I need to talk to you. Some variation of that?
The direct language was, I need to speak to you.
I need to speak to you. It's close enough for government work, okay? At that point, is your client free to go or do anything?
At that point, no reasonable person would feel free to leave the scene at that point. That the need to speak language demonstrates some sort of bona fide authority that they are there because they are entitled to be there to talk to them.
And this could be determined as an acquiescence to authority at that point?
Absolutely.
You got the gun, you got the badge. This is not undercover. This is police officer. We know it's a police officer?
Yeah, all four officers were in their vests and badges.
And everything, right. And no question that this is the badge, the imprimatur of authority. Need to speak to you. Guy says, okay. And walk me through the facts from there.
At that point, once they are stopped, he says, I need to speak with you. They have a short conversation at the car. They walk towards the front of the house. And he takes a brief break at the front of the house before ultimately letting them in.
You're talking about the defendant takes a brief break before.
That's correct. The defendant does.
Now, there is some story about keys being taken away from the defendant. You're not even throwing that into the package here. Not important?
I don't believe so, Your Honor. At that point, he was already seized, and it just demonstrates that there was no break in the chain of events.
In your analysis, it doesn't make a difference.
That's correct.
Okay.
Thank you very much, Your Honor. For those reasons, we'd ask that this court reverse the decision of the court below.
All right, you still have 2 minutes left for rebuttal. We'll hear from the state, and then you can rebut.
Yes, this is Court. Good morning. My name is Douglas Lake, counsel on behalf of the state of Florida, appellee in this matter. The state would submit that the trial court's ruling is supported by competent, substantial evidence. The factual findings are it was within the province of the trial court to make the credibility determinations.
But why do we even get to credibility and consent if you have an illegal entry? If you have an illegal entry and a seizure based upon an illegal entry, then don't you have to first have something that occurs to dissipate the taint before you even get to consent?
Well, Your Honor, we don't. The trial court found no illegal entry. She found a consensual encounter.
Well, but that's a legal question. That's not a factual determination.
Correct.
So let's address that.
Well, the state would firmly submit, Your Honor, that there is no illegal entry here. The gate was open.
But
and the officer walked through the gate.
You have a property that's completely enclosed by fence, and it's a high fence, and there's bushes and trees all around the fence, and you can see over the fence. It hasn't, and gates that are normally locked that just open so that the defendant can drive out.
Correct.
Wouldn't you admit that presents a reasonable expectation of privacy? That Mr. Fernandez didn't want in, and even had his mailbox outside of the property, so the mailman can't come to his front door. Doesn't that tell all the people of the world, don't enter my property without my permission?
Well, yes, it does, but his gate was open at the time the officer walked through. You have to go with what was occurring, not what maybe 10 minutes before it was closed.
If you have a car or you have a house and you open the door to exit it, is that an invitation for anybody in the world to walk in? Obviously.
Well, no, but I think a good way to look at it is for this court to imagine, what if we had a salesman standing there when that gate opened? Now, the officer does not have any less rights than a salesman.
Well,
the gate opened, the salesman just walks up to the car and asks, hey, Mr. Jones, can I speak to you? That's exactly what happened here.
He'd have to stand outside that gate and ask for permission to enter.
The salesman would have to ask for permission?
I think anybody would. When you have taken such precautions to tell the world that this is a private piece of property and you don't want people to come in without permission, then just because you open a gate to drive your car out doesn't change the message.
Well, I think that's the crux of it. I think Your Honor hit. That's exactly where we are in this case.
And do you have
was the officer reasonable, within the meaning of the Fourth Amendment, was the officer reasonable in walking through the gate? That's the crux right there. And the state submits, with all due respect, that the officer was reasonable when he walked through the gate.
Let's see if your position holds water. What if he wants to drive out and he's prevented?
Correct.
That's what happened.
Illegal.
Right?
Illegal.
You're driving out of your driveway and anybody, police officer or otherwise, just pulls up and prevents you from driving away. At that point, this is not just like something, even standing outside the salesman, because you could drive by the salesman if you wanted to and not speak to him or her. But on the other hand, in this case, you can't drive by that person because you're blocked. So you're stopped at that point.
Well, no, I would submit, if you look at the facts, the initial officer, Falcone, parked on the side. Okay. So he didn't block anything. And Detective Murillo, if you look at his testimony, Murillo, when he came on the scene and, quote, blocked, that was after the defendant was already out of the vehicle and walking. That's when Detective Falcone said, come waving in. They were outside the vehicle walking towards the residence.
Okay, I got my facts wrong.
They were walking towards the residence. Murillo did not block. There's absolutely no blocking in this case.
Okay. Do you have any case that you can cite to this court where a homeowner or a renter, doesn't matter, has an enclosed piece of property where they have found that you can enter simply because you open a garage door or you open a gate and it now provides access to somebody?
Well, I'm trying to think. I did supplement recently with some cases. They say the officer has a right to make a path. Generally, Roger's case that I cited at Texas, it's kind of like if the officer takes a path that he can't take lawfully, and that's what the state's kind of relying, is they're saying the gate was open. We're saying he could have walked lawfully through the gate because it was open. And if you can take that pathway, like, for example, this defense site Quintana, I think he mentioned Quintana case, the officers there jumped over the fence. That's not a normal... That's not the normal way to do it.
Do you have to put up a no trespassing sign or a bad dog sign to have people respect your property?
Well, no, Your Honor, no, probably not. And that would have... that makes a difference because that distinguishes the defense case. They cite another case where there was no trespassing sign. I think the Brinks case, they cite a Brinks, but that's no trespassing sign.
Let's look at this as this courthouse. Now I'm thinking about it. You're raising some good questions, Judge Rothenberg. I'm just thinking about it too. We need a little pass to get to the upstairs. Call it the penthouse here. See that little thing? That gets me upstairs. You can't get in without this. If you're in a place where you don't have this little pass, and some judge comes walking by, and they don't intend for you to go up, and they open up the door so they can go through, and you go through, that's kind of what we have here. You're not an invitee at that situation. You're just walking through a place that you're really not wanted. Is that what we have here? Well, one might not be one.
Yeah, it all gets to reasonableness. That's what I come down to. Is it reasonable? Was the officer, quote, reasonable? Because that's what the Fourth Amendment deals with. That's what the Fourth Amendment prohibits. Unreasonable. I think it's reasonable for an officer when a gate is open like this to at least, I agree, he couldn't do everything. He couldn't jump over the gate. He couldn't do a lot of things. But one thing I think he could have done is just walk through that gate, and the car was right there, and he came approached the defendant and said, can I talk to you, and then the defendant rolled the window down, and that's the actions. Were those actions reasonable or unreasonable?
I would agree.
The state would submit they were reasonable.
I would agree with you if the scenario was different. If you had a closed, gated piece of property, and the gate is open, and let's say the defendant was in there washing his car, or doing some gardening, or playing with children in the yard, and that gate's open, I think you're on solid ground. Can walk in, no problem. But when you have officers waiting outside of this property and the gate is closed, and they know they can't get in, and then they wait until the defendant comes out of his house and opens the gate in order to drive out, I think it's a very different scenario. Because he hasn't opened that gate to allow people to come in. He's opened the gate to allow himself to go out. And I see that very differently. That becomes a fortuitous opening, and they were waiting. They were there waiting. If this had just happened on the scene and the gate was already open when they got there, you might have a stronger argument, even if he's leaving in his car, because they could say, well, the gate was open, so I thought we could go in. But when you have officers sitting outside a property where the gate is closed, and it's only open to allow him to leave, and that's clear what's going on because they're watching this happen, I don't find that.
Well, Judge, I would just beg, Your Honor, to view this as what if a person, a salesman, some person, a casual visitor to that residence. I don't think you could say when that gate opened that if the casual visitor walked in there that they would be in violation of trespass. That's not and the officer, a reasonable officer, is like a citizen investigating. I mean, he's a person that's investigating a crime. He has a job just like a salesman, and I don't think that a officer should have less rights than a salesman. I don't think anybody would say that salesman would be guilty of trespass going in that gate. And so the state, it gets to reasonableness and how we look at reasonableness under the circumstance. I think that's two critical issues here, Judge. Is we have the expectation of privacy, which I appreciate Your Honor's concerned with, and that's a good concern to have, the expectation of privacy, and we don't want to have our privacy violated. But in the Fourth Amendment, not only talks about the intrusion into privacy, but that it has an unreasonable requirement. It has to be a police action that's unreasonable. And so I just don't think under these circumstances it was unreasonable. I'm sorry, Your Honor.
I've already forgotten. Okay,
wouldn't it have been more reasonable under the circumstances of this case for the officer who did park his car outside of the gate to simply say, excuse me, sir, can I speak to you for a moment? From outside the gate. Or can I go?
Yes, I
do you mind if I come in and speak to you for a moment?
Well, that's more reasonable. It's also
Fernandez would have said yes, and he would have walked in, and that would have been the end of the story.
Yes, the scale of reasonable. It's like it's a graduated, like a ruler with how much reasonableness we have under each in each of these cases, obviously fact specific, and the state would submit here that the trial. But then what we're here now is on what a trial court did, and whether the trial court was unreasonable basically in what she did, and the state would submit that there is a presumption of correctness. There's a presumption of correctness in what the judge did, and I don't think it was.
Well, not when you're addressing an issue of law. It's a different story when you're looking at factual determination.
Well, it's a pure question of law, yes, would be de novo.
Right.
So the state would ask for an affirmative. Thank you.
Thank you.
Rebuttal?
Just have one comment on each of the two issues. As to the first issue, the trespass, Judge Rothman, you're exactly right. The reasonableness is when if he had waited off of the property and proceeded to that point. That I can see that if an officer shows up to a house and the gates are open and they have no idea that the expectation of privacy exists, at that point it would be reasonable to enter. But given that the officers knew of the expectation of privacy, that is why this is distinguishable from those cases that hold an open gate is okay to cross through.
Must this reach the level of a trespass in order for the Fourth Amendment to be implicated?
I don't know if it must or not, but I do know that if any other person had crossed onto that property, I think it would have also been a trespass. That everything about this property demonstrated an expectation of privacy. And the fact that the officers were there while the gate was closed just even more solidifies that, and they knew that they could not go onto the property while the gate was closed. And so when the gate was opening, that doesn't mean that he lost his expectation of privacy. It just meant he was trying to leave his property. And so I think that if anybody else, including the officers, had gone on, that is a trespass and an unreasonable entry into the Fourth Amendment. The second point on the second issue is that the car was blocked, and I understand the language might suggest that he was already out of the car by the time Murillo parked his car, but the two officers give kind of conflicting testimony. At any rate, they occurred nearly simultaneously. But what did occur first was when Detective Falcone approached the car, he said, "We need to speak with you. If you didn't ask, may I speak with you?" And I think that language, along with the other factors, demonstrates that this was not a consensual encounter. It wasn't something that Mr. Fernandez could retreat anywhere from, and any reasonable person would not have felt free to. And for those reasons, we ask that this court reverse the decision of the lower court.
All right. Well, thank you. I do have a